I'm just plain Bill, and this is Thoughts While Thinking, and these opinions are mine. And we're looking at this Supreme Court ruling on Trump's appeal, and there's a lot of misinformation out there, so we're trying to find the facts, just the facts, ma'am. Everybody's entitled to their own opinion, but not to their own facts. A fact is a piece of information that can be strictly defined and proved and to be true. An opinion is a statement that expresses a belief or value or feeling, and an option cannot be proved true or false. And so that's where we're going, and we're taking a look at it. And we're going to see whether we got the facts or opinion.
One case the court's decision appends includes special counsel Jack Smith's January 6th case against Trump.
In other words, it's going to be very challenging for Jack Smith to win the argument that everything alleged in the indictment is an unofficial act.
Citing the new decision, Trump has moved to overturn his recent hush money conviction in New York. Trump's attorneys are now asking the judge to allow them to challenge the verdict, which, if allowed, would delay Trump's sentencing set for next week.
Well, here's a former Trump special counsel, Ty Cobb, and he's expressing some opinions, but I think they're based on facts, so we got to take a look at it. Fact or fiction?
But it's not surprising that it's going to be one of the last opinions announced. And I think the result, which will be dramatized in a way that will be overstated, just like the Chevron and the obstruction cases. But it, to the shock of many people who have been condemning the court for taking the case, this case is not going to help the president at all. They're going to draw a line. That line is going to encompass and include within its capabilities for prosecution virtually all the conduct that's alleged in both the federal indictments against the president. It may require some line drawing. I mean, it does require some line drawing, which is the only reason they took the case. Had the D.C. Circuit drawn that line, which they did not, to the frustration of the Supreme Court, they perhaps would have accepted the D.C. Circuit opinion, but the D.C. Circuit didn't give any guidance to a trial judge in fashioning jury instructions about how does the jury decide whether this conduct is covered. And that's what's going to come out of this opinion. They're going to say, this is the line. It may be as simple as official acts and personal acts. And keep in mind that, Justice Coney Barrett, during oral argument, got Trump's lawyer to concede that virtually all the conduct in the January 6th indictment is covered as would be prosecutable as personal acts. So I don't think this is going to favor Trump at all. I think this will be a bad decision for him. I think it will be consequential and certainly allow him to be prosecuted. I think the problem here is because of the timing. Trump has been a great beneficiary. I think that people can blame the court. But the real delay here was the January 6th committee's refusal for 8 months to share transcripts.
It appears to me that this one is about the best opinion that, based on facts, that I could come up with. So we're looking at just the facts, ma'am, just the facts.
The Supreme Court ruled that former U.S. presidents retain significant immunity for acts taken while in office. New York University law professor Ryan Goodman breaks down the court's opinion and what it means for Donald Trump's election interference case.
This is an enormous case for the court. It's one that will be studied for decades. They basically divide up all the allegations against President Trump into three categories. Category one, issues that are within the president's core powers and he's completely immune from prosecution. Those issues can't even be used as evidence in the case. A good example of that the Supreme Court gives is the pressure that President Trump is alleged to have applied to the Justice Department. The majority says that is within a president's core constitutional authority. A second category is a middle category, things for which a president is presumptively immune, but the government could rebut that presumption and they could potentially be used in the case. A very good example that they give of that is the president's communications with the vice president. And for that, the court says that the lower courts will have to determine whether or not those will maintain their presumptive immunity. And then there's a third category, actions that a president takes that are within his or her personal capacity. Those are not immune and they can be prosecuted. The court speaks to the future. It's not just about the immediacy of President Trump's trial. Big questions about whether a president could ever be criminally prosecuted or criminally liable for directing their Justice Department, for example, to prosecute individuals at their own behest. The court seems to be saying that that is an absolute power of the president that is not subject to review by prosecutors or by courts.
Well, there's your opinions and facts as they were presented. And I appreciate you watching. I appreciate you subscribing. And I guess the facts will turn up and fall out in the court system. Well, it's adios, amigos, and we'll see you on the flip side.